InnoTalks is an informative venture of InnoStack, a subsidiary of Microsoft Technologies InfoPark. We will be bringing in industry experts to share their experience and thoughts. This will be an excellent opportunity or experience for your business and career. Stay tuned for more videos.
IP, I would say that for all the startups, this would be the trump card for them. One is that when you are actually able to create an IP portfolio, that would help the company to escalate to the next level when they are, let's say, they are looking for the seed funding or another kind of investment coming into the pictures.
Today in InnoTalk, we have Adv.Vineed Abraham, Managing Partner of Brands and Bonds, a fully fledged legal firm. Mr. Vineed Abraham is an IP attorney. So today he is going to share with us his perspective on IP. Welcome, sir.
Thank you.
Sir, IP is a common term which is used in the current business world. So still there is a confusion between IP and patents. So are they really same, or is there any differences between that?
Usually this is the biggest misnomer that's happening in the current scenario. IP is much more wider, and patent is one of the ingredients of an intellectual property, or the so-called intellectual property rights. So intellectual property rights would include patents, copyrights, trademarks, designs, and obviously the semiconductor chips and plant varieties. So commonly used with regard to the commercial aspects of it, we can say that the intellectual property worldwide would include patents, trademarks, copyrights, and designs. So patents is different and intellectual property is different. Patent is comparatively one of the components of intellectual property rights.
Okay, so which means it has more dimensions.
Absolutely. Patents is for inventions, whereas trademarks is for the brands, protections, and copyright is for the human ingenuity, which is creative works like artistic work or cinematograph or musical compositions, etc., etc. And designs is for the aesthetic aspect of it. So whenever there is an article which is having some kind of an aesthetic appeal, it is capable of being registered as a design. So that's the basic difference between. Yeah.
So if I have an idea or something like an idea to build a mobile application or starting a new service, so can I patent this idea?
See, there is a big divide in understanding this aspect also. Idea as it is something which is rusting in your brain, which is unless and until that is transformed from that particular brain vibrations into a tangible medium. Once it is actually transformed into a tangible medium, then it becomes it can be protected under any of the connotations of the intellectual property. It could be either a copyright or a patent or something like that. With respect to your question with regard to the software or mobile application, in India the software per se is not a patentable subject, which means that per se simply means that as it is. So if you are writing a code like a mobile application or any other softwares, etc., that is not a patentable subject in India. Having said that, Indian benchmark is that if you have a technical contribution, let's say it is having some kind of a connection with the hardware, then it becomes a patentable subject. So in a nutshell, the divide is that if it is only a software, it is nothing but only a software, then it is not patentable as per the Indian patent office. And if it is having a technical connection, then definitely it could be patentable.
So which means we can't patent a mobile application as it is.
As it is. But if the mobile application is having a technical connection, as I said, there is a technical connection with any of the handset or then it becomes a patentable subject. Having again one more thing that we should add over here is that from 2013 onwards, we can see that there is a huge trend in filing a lot of mobile applications which are not yet reached the grant stage, but still that's published. Maybe you can find, if you simply cross check, you can find around 15 to 16 mobile applications which are actually published right now in patents website itself. Yes.
So basically in India, what is that duration taking? for getting a patent approved? Or?
In India, it would at least take 4 to 5 years to get a patent grant. Yes, and there's a lot number of things which are correlative and dependent on that time frame. You have once you file a provisional specification, if you are filing a provisional specification, you have a time span of another 12 months to file the complete specification. So, but if you don't want to actually leave that 12 months period, you can straight away file the complete specification. So in one sense that you will be able to gain a period of 1 year over there. So whatever it is, it would take around 4 to 5 years for getting a patent.
Okay, so if I apply for a patent for something, so I need to wait for another 5 years, or while this patent is approved, the technology can be changed or something. So
you mean to say that the technology could be obsolete by the time the patent is granted or something like that? The answer is again yes and no. If the technology becomes obsolete, yes, you have lost or you don't have otherwise the patent is actually giving you a monopoly. There's a 20 years monopoly. So in the 20-year monopoly, 10 years is gone. But still, when you are filing a patent application, the main aspect of it is that you will be able to eradicate the competition from others. If you file an application in India also, the patent benchmark is that it is available or it should be treated as a prior art. That's a term, prior art all over the world. So you mean to say that if you file a technological patent, that application itself can enable you to exclude other competitors from the market. So you can treat it as an advantageous position. Like you don't want to actually wait till you get a grant to actually market it also. Once you file the patent, you have crystallized your rights, and you are in the way of crystallizing your rights. So you can market it. So that way it would be an advantage.
Sir, if I have a revolutionary design concept for a bottle which can be used by kids, can I protect that using any patents or something like that?
As I said, patents is for inventions. If the bottle is having a unique design which is appealing to the eye, aesthetically appealing, then it becomes a subject matter of designs and not of patents. Because the only invention over here is basically the shape of the bottle. So design stands for that itself. Design is for aesthetic, like if an article is of aesthetically appealing, like the perfumes. One of the best examples is that in India the fragrance is not capable of being registered as a trademark. But in France and all those things, there are a number of perfume bottles which are actually being registered as a design. So you cannot actually trademark the fragrance, but the other way to get a protection, some way of protection, is that the perfume bottles will have a unique shape, which is aesthetically good. So that will be capable of being registered as a design. So that's the way in which it has been taken up.
So this is how it's done. So what about the patent we are acquiring from India? So if we consider another country, so what is the validity or what is it? Exact importance of a patent which we took from India?
So all the intellectual property rights are for India, specifically for the territory of India. So if you have a registration or a grant of a patent, that is applicable only in India. And for a trademark, it is applicable only in India. Design, again, it is applicable only in India. But there are international conventions which have helped in getting the protection outside the territory also. So if you mean to ask me that whether the patent granted in India is equally good enough in US, the answer is simply no. But having said that, there is a PCT, that is a Patent Corporation Treaty, which helps you to file the application in US also. So you need not actually draft again and file it in another country, US or whatever country you choose. You have one window mechanism where you can file the application in the other jurisdictions and again go through the same procedures that you go in India and obtain a patent in that particular country. So to precisely answer your question, no.
So now we came across a good discussion regarding patenting. So now I would like to switch to copyrights. which mostly entertainment segments is in need of. Especially when I heard something like Gopi Sundar, the music director, he's in a contract with the director of a particular movie or the movies he's handling. It's like he won't charge for making that song, but eventually that song will be his. So we need more clarity, or could be better if you can explain something regarding copyright for music, so how it is happening.
Okay. See, copyright as it is, there are a lot number of components for copyrights itself. First is the artistic work. Second is musical composition. Third is sound recording. Fourth is cinematograph. And then dramatic work. These are the components of a copyright, or which are capable of being registered as a copyright as it is.
Okay.
So musical work as it is itself a copyrightable subject matter. When you say musical work, the notations are the one which are actually being registered as a copyright work. And for the most important thing is that copyright registration is not mandatory.
Okay.
As soon as the work is completed, it is presumed to be copyright protected. That's why you can see that almost all the websites use a scene circle and say all rights protected and all those things, etc. Which means that the work is completed, you get a copyright over it. But having said that, that doesn't have any proof, or it doesn't give any evidences to whether who is first or. So that's why people prefer to get a registration of the copyright also. Coming back to your question, the musical notations will be capable of protection as a copyright. And sound recording, when you say musical notations, it doesn't have vocals. It is just the notations that is which is basically copyright. And then sound recording is basically which is having all the medium, like the sound, the notations, the other compositions, everything collectively in a medium. So you have the protection. You can actually either protect it as a musical work or with the all combined work of sound recording. So that's a choice that you make. How do you actually have to protect? With regard to Gopi Sundar, the music director, there are, for a cinematograph, it's actually treated as the producer is the person who is having the ownership of it. So generally, so for let's say somebody has written a script, then the script is actually bought by the producer and he uses it. The cameraman is actually hired by the the producer and he uses that. So this is the concept basically. There is a slight difference with regard to the lyricist and musical composers, which the musical composition itself can have a stand of its own. It can be used in a cinematograph, and it can have an individual identity of its own. So Gopi Sundar, A.R. Rahman and few of the other musical composers would prefer the ownership to rest with them rather than the producer of the film. So that's again a choice. It's again depending upon the bargaining power of each and every musical composers, and so this is in a nutshell. So he preferred that he would not sell his music to the particular cinematograph, but he would actually license it to the.
So eventually he is the guy who is selling his songs.
Correct. He would be. He can actually, if you see that the Hollywood never actually hires, the producer never hires it for, or it's the ownership is still with all the musical composers itself. So you can see the same music in many number of films.
I have a friend who draws cartoons and also draws comics. So is there anything that can protect her works?
Yes. Cartoons or caricatures are actually capable of being protected as a copyright. There all these things, as I said in the initial discussion itself, like the caricatures or cartoons or artistic work will all fall under as an artistic work. So it is capable of being registered as a copyright. But interestingly, there is a very interesting case with regard to the design of a bag, which was actually the litigation between VIP and Samsonite. It's usually called in the legal fraternity as the Samsonite case itself, which was argued by two pillars of the judicial, the legal fraternity, Arun Jaitley and Kapil Sibal on that. So there is a big divide, like the protection for a design is for a period of 15 years, whereas copyright is life plus 60 years.
Oh, okay.
So there is a substantial lifespan for copyright.
So what is it? Life means? What will be the span?
Monopoly. Basically the monopoly.
Ultimately monopoly.
Ultimately monopoly. So copyright belongs to somebody for his entire life period plus additional 60 years. So there is a wide span of this thing. But protection with regard to copyright is much more huge sum, or it will take some more effective mechanism to curtail any kind of copyright infringement. Whereas designs and other things are much more easy when it comes to any kind of infringements, etc., etc. So with regard to this particular case, what had happened is that a particular company had Samsonite or VIP had the design protected, and they had the sketches also. So when the design expired, they said that it was actually they can extend it to the artistic work. So that means the life plus 60 years. So there is a provision in the the Designs Act which says that if the industrial work or the article, the design has been used for more than 50 times, then it loses to be capable of being registered as a design. So you can only go back to the copyright. So there is a very small divide. So if somebody is actually thinking about protecting the design, they should actually go ahead and do the designs rather than go and apply it on the article and make it industrially applicable. Then they will lose their right. So basically, normally the first and the foremost thing that comes to a new business or a businessman is a trademarking thing, like protecting their brand. So how can someone protect their brand? See, again, trademarks, there are different ways in which you first of all identify a trademark. The mark can be a logo. The best example is Nike. The tick itself is a logo. You identified that. Then you can have the word or the letters Nike, Adidas, or whatever. Apple. Apple nowadays doesn't actually even use the word Apple. It's the logo. Just placing the logo. So these are the ways in which these are the different components of a mark. It can be either a label one, or it can be a logo. It can be word mark. So these are the ways. Once the company identifies any of these, the way in which they want to protect it, then doesn't make any big difference, because the filing applications and all those things are one and the same for even if it is a word mark, or even if it is a label mark, or is a logo mark, so whatever it is.
The process is similar.
The process is similar. The process is similar.
Okay, so that's yes. So if we all know that there is a brand called Apple.
Yes.
Spelling is APPLE. Can I go for a trademark for APPPLE?
No, you cannot, because one of the benchmarks is that it should not be similar to other existing marks. First is that, and your brand should actually be capable of identifying its goods or services as of its own. Rather than you should not be riding on somebody else trademark. Apple, as you know, that's very famous mark itself. Two risks are there. One is that you will not be able to obtain another trademark on that. If you accidentally get a registration of it, the Apple brand will actually fight it against you.
Okay. So is there any criteria for selecting a trademark?
Yes. There is a big difference between the persons who actually create the brand or a trademark, like ad agencies, and lawyers like us who actually file the trademark. The first and the foremost benchmark is that you should not describe your goods or services. So in very simple terms, Apple cannot be for the fruit apple. Or BlackBerry cannot be for the fruit BlackBerry. So it should not describe your goods or services. But again, Apple is a very good trademark when it comes to the computers or computer applications and other aspects. So BlackBerry is good for mobiles. So that's the way in which is to be taken. So the first and the foremost thing is that you should not describe your services. Let's say you are having some kind of a through the name. Let's say you are having some kind of a laundry services or some kind of a software development services. So if you name your laundry services as laundry itself, it is going to describe your service. So that's not actually allowable. correct, that's not allowable in the it should not again describe, it should not have any kind of correlation with what you are supposed to do with your goods or services. There are interesting aspect of it that there are few lucky ones who was able to actually get trademarks which in a way was describing, and at the same time it was not within the connotations or the legal bars of this. I would say that Good Night is a very good brand which actually tells you that once you plug in the Good Night, you are going to have a good night's sleep. Rather, it doesn't actually explicitly spell out that it is a mosquito repellent, but it sends out a meaning. And again, sleep well. When you say sleep well, you get to say that you are going to sleep well, which would be
their mattress.
Correct. So these are a couple of indications for a good brand. The point that you should take is that you should not describe your goods and services.
Okay. So how much time we will take for getting a trademark in India?
For registration, in the current scenario, it will take around 1 to 1.5 years for registration. Earlier, it was not the scenario. It would have taken around 5 years from filing date till registration. But there is a huge number of backlogs has been cleared off, and right now the scenario is that it would take around 1 to 1.5 years. 1 to 1.5 years.
Okay.
Yes.
So moving on to a startup question. So for startups, how important is this IP protection?
See, IP, I would say that for all the startups, this would be the trump card for them. One is that when you are actually able to create an IP portfolio, that would help the company to escalate to the next level when they are, let's say, they are looking for the seed funding or another kind of investment coming into the pictures. The main trump card would be their patent portfolios or intellectual portfolios itself.
Okay.
So that one is that they are very serious about their IP or their own rights.
Okay.
Second is that when you are having a lot of patent portfolio or this thing, the investors would be much more interested in taking some stakes into your company.
Basically startups or
any company, but startups would not have any other advantage rather than having any intellectual property protection.
Okay.
So for them, it would be much more better to have that portfolio built up.
Okay.
Very seriously think about it and have done. Comparatively, a patent would be much more on a costlier side among the other IPs, but still have a budget over it, have a serious thought about it, try to build up the patent portfolios, the technology and all those things, so that you will be able to actually escalate it to the next level when the investment comes into all this thing. You'll have much more financial muscle power when the angel investors comes into the pictures and all those things, etc. So definitely the trump card would be intellectual property portfolio itself.
Okay, so basically I have more questions for startups, but due to the time constraints, we are moving that to our next session. So there are many initiatives happening from the side of government for the startups. So which is the best thing which they can choose from?
See, the central government itself is having a pet project with regard to the startups. Startup India is one of the mottos of the central government itself. And there is a lot number of tax leverages that is granted to startups. What exactly is a startup is again a qualification, or they have come up with a definition of what exactly is a startup itself. And then when you're filing a patents and all those things, etc., to file a patents, there is a lot number of leverages. So the cost leverages are there for startups, and so there is a lot number of initiatives. I believe in the next coming budget or something like that, we will be able to see much more tax incentives and other initiatives from the central government with regard to the startups.
So which means there are much more things.
Absolutely, yes.
Which can be happening in another session.
Absolutely.
So that was Adv.Vineed Abraham, Managing Partner, Brands and Bonds in InnoTalks. Thank you so for joining with us.
My pleasure.
So this is Arun Shah signing off from InnoTalk. Thank you. Stay tuned.